And so it begins.
Yeah.
All right. Let's stand for the pledge to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, take a moment to look over the minutes, and when you do, and you have, I will entertain a motion for acceptance of the minutes of our last meeting. Commissioner Flora will be abstaining.
Move to approve the minutes.
I'll second.
All those in favor, say aye.
Aye.
Aye. All right, the minutes are approved. And do we have any special announcements or special agenda items from staff?
Yes, I do. Thank you. Good evening to the board and members of the public. I wanted to mention our next seminar is the annual Landlord-Tenant Forum that we offer with the Consumer Protection Division of the City Attorney's Office. It's on landlord and tenant rights and responsibilities, and it's part of the city's ongoing effort to increase public awareness of how local and state laws impact landlords and tenants. This will occur on December 5th in the morning at the Thelma Terry Center in Virginia Avenue Park. And we'll have a general overview of the rent control law, as well as discussion of buyout offers, tenant harassment, school year eviction protections for students and educators, and source of income discrimination in Section 8 vouchers. All Santa Monica tenants, property owners, property managers, advocates, and anybody else interested is invited to attend. There is a limited capacity, so very soon the City Attorney's Office will be putting a sign up on their website. We'll have information on our website as well, but registration is required by December 1st.
Would you repeat the date and time, please?
Yes, it's December 5th from 9 to noon at the Thelma Terry Center in Virginia Avenue Park. And then I also wanted to mention that the maintenance seminar that we conducted on October 16th with the Code Enforcement Division was videotaped and is now available online, and it's chaptered. Excellent. So that somebody can go directly to the section that they're interested in. So that's available, and we thought it would be good to note that this evening, since Commissioner Flora has been very committed to us getting these types of things on the website. And finally, I wanted to mention that the fall newsletter will be mailed out the first week in December. Tenants' copies will have copies or the maximum allowable rent for their unit printed on that. So people should watch for that in early December.
All right. Thank you. We do have a consent item on our agenda tonight, and I would like to entertain a motion from someone.
Public.
I'm sorry?
Public comment.
Oh. I checked it off the list a little too quickly. We do have a person wishing to publicly comment tonight. This is the time we set aside in each meeting to hear from members of the public on things that are within our purview, but that specifically are not on the agenda tonight. Rhoda Makoff, come on up. You've asked for 2 minutes. When you start.
Hi, I'm a small property owner, and I was at the last meeting when we were under the concern about Costa-Hawkins. Well, Costa-Hawkins went down, but it won't be down forever. The people supporting it are very, very passionate, and even though renters and owners weren't that interested in it, apparently it will be back, and it might be back in 2020. I was very impressed with all the research you were going to do, looking into who owns what, the impact. And we know that Santa Monica needs to do something, upgrade what its base rent is. And this is just a plea, really, to not drop the subject, not table it, but come up with perhaps something that, if it needs to be voted on, can be on the 2020 ballot that somehow brings base rent into conformance with 2020. Thank you.
Thank you very much for your comment. All right, that concludes public comment tonight, and we move on to item 9, the consent agenda. And again, unless someone chooses to pull it, I'd like to entertain a motion to approve the consent agenda.
I move to approve the consent agenda.
Is there a second? Second. All right, it's been moved and seconded. And roll call vote, please.
Commissioner Flora,
Yes.
Commissioner Trosas,
Yes.
Commissioner Duran,
Yes.
and Commissioner Foster.
Yes.
Motion carries.
All right, moving on to our jurisdictional items. We have item 10A, an owner occupancy exemption. So I would suggest that both of these items, 10A1 and 10A2, seem to have no irregularities, no tenants in either case, and pretty straightforward. So unless someone feels differently, would someone please suggest a motion?
Thanks. I actually agreed with that. I would move to approve the findings of fact. No. Yeah, no, I'm just checking that that's what it is. Okay, yep. Findings of fact and conclusions of law in both 10A1 and 10A2.
I'll second.
Okay, and before I call for the roll call vote, I just want to tell the public that when we do that, it's because the findings are so clear and straightforward to approve these two owner occupancy exemptions. We don't feel the need to spend time debating it when it's pretty clear cut. So will the clerk call the roll, please?
Commissioner Flora,
Yes.
Commissioner Duran,
Yes.
Commissioner Trosas,
Yes.
and Commissioner Foster.
Yes.
Motion carries.
All right, moving on to item 10B1. These are appeals. We have 3 appeals tonight. The first appeal is case number D-5057-707 Idaho Avenue, Unit 107. Appellant S. Sterling on behalf of Sterling Family Trust landlord. Landlord appeals hearing officer's decision granting a rent decrease for lack of adequate management services. Can we have a staff report, please?
Good evening, Commissioners. Jackie and Jesse Pizzante had been on-site managers at 707 Idaho Avenue for 20 years. Recently, Jesse's health deteriorated, and as the couple coped with age-related health problems, their attention to management services waned. I unfortunately understand that Mr. Pizzante has passed away since the decision was issued. Gene Morello and Deborah Senapol are tenants in Unit 107, and understandably they had grown frustrated with the decline in management services. They filed a petition for a rent decrease alleging various reductions in housing services and maintenance conditions. The Sterlings, who own the property, hired Alex Verhoftig, who lives close by, to help the Pizzantes with their duties. The hearing officer found that with Mr. Verhoftig's help, management addressed the complaints Ms. Morello and Senapol had alleged in their petition. So the hearing officer awarded no decreases for maintenance. However, he granted a $40 decrease for lack of adequate management services. The Sterlings have appealed the decision and argue that the hearing officer erred in granting a decrease for lack of adequate management services when he had found that the landlord had addressed the deficiencies alleged in the petition. They raised other objections, arguing that they have always provided repair and maintenance services as evidenced by newly submitted expenditure records, and they state that the hearing officer erred in admitting into evidence letters from other tenants despite their being hearsay. They also took issue with the vagueness of the hearing officer's conditions for compliance. California law requires an on-site manager for properties of 16 units or more, such as this one. The law does not define the scope of management services. Nevertheless, the record shows that the Pizzantes who have been struggling with medical problems had become deficient in their management. Ms. Sterling herself acknowledged the flurry of recent tenant complaints. But the record also shows that Mr. Verhoftig had addressed the complaints, specifically the ones in the petition. He replaced the hot water tank to avoid further interruption with hot water. He abated the rust of the surface of the bathtub exterior, had a contractor adjust the living room window and replace its screen, recalibrated the oven so it could cycle correctly, and cleaned the oil stain in the on-site manager's parking space, and told them the car could no longer be parked there until the oil leak had been repaired, and installed additional security camera and bolted gates to address security concerns. As a result, the hearing officer found that the evidence did not warrant any decrease for the maintenance conditions that Ms. Morello and Ms. Senapol had raised in their petition. The hearing officer also noted the absence of any evidence as to the level of management services provided when the base rent for this unit was set. Because there is no evidence of the level of non-maintenance related management services originally provided, the hearing officer could not have found that those services declined, and he didn't do so. Nonetheless, he still granted a decrease for inadequate management services. He stated that he did so because the tenant's maintenance requests had been ignored for years and no real effort had been made to address them until after the petition was filed. But except for construction decreases, as specified in that regulation, rent decreases may only be granted on a prospective basis for an ongoing maintenance condition or reduction of a housing service. They can't be awarded as a punitive measure for prior failure, as compensation for previous deficiencies, or to discourage past problems from recurring. Because the hearing officer had found that Mr. Varhaftik and the Pisantes had finally remedied the maintenance conditions alleged in the petition that's before you, and there was no evidence of a reduction in management services from the time that the base debt had been set, the Charter gives no basis on which to grant a decrease with respect to the level of these services. The Board isn't empowered to grant a decrease for corrected past conditions, nor for things that may but have not yet occurred. To do so would be punitive, compensatory, or based on problems that are not in evidence. Staff therefore recommends that the Board reverse the decrease granted in this case, but to also waive the 6-month waiting period before Ms. Morello and Ms. Senapol may file a new petition in case management again fails to respond to tenants' concerns in a timely manner. Because the record doesn't support the rent decrease granted as a matter of law, the Board need not address the objections raised about the admission of hearsay letters or the vagueness of the compliance condition. The Board should reject the newly submitted evidence from the Sterlings because they could have submitted them to the hearing officer through the reasonable exercise of due diligence. Staff also asked the Board to modify the paragraphs noted in the staff report in the decision's findings of fact and conclusions of law so that they conform with the recommendation before you.
Thank you. We do have some speakers on this item, but I would like to take the extra step before we start that hearing from the public. Council, can you please advise the public and the Board as to, we have so many letters and so many extra attachments that came after. Can you please say a few words about the procedure here before we hear from the public?
Because this is an appeal, meaning that the Board is examining whether, based upon the record as the record existed when the hearing examiner made the decision, that decision was correct, either legally or factually. Nothing that happened after the hearing happened is relevant. Nothing even that happened before the hearing but that was not included in the record is relevant either, unless it has a direct bearing on the issue that's under appeal and unless the person who seeks to enter that new evidence can show that they could not have entered it at the hearing through the exercise of due diligence. So this is not a fresh hearing on, the Board is not in the same position as the hearing examiner. They're only asking, in general, given the record as it exists, was there a clear mistake? In other words, is it the case that no reasonable hearing examiner could have made the decision that he or she made based upon the facts, or was the hearing examiner's conclusion of law legally erroneous? Is that sufficient to answer your question?
It is, and I hope it is for the public as well. So we're going to restrict our comments to the appeal at hand in this case. We have 3 speakers on the item. Shelley Sterling is first, followed by Jean Morello and Deborah Senapol. Shelley Sterling.
And Commissioner, the time clock is not working over there, so with a minute to go, I'll warn them there's a minute to go.
Okay. You have 5 minutes. Up to 5 minutes.
I really don't have too much to say except our last hearing that we had with Ms. Senapol was we weren't aware she was bringing an attorney, number one. Actually, she brought 2 attorneys. And we answered all the questions. We did all our things that we were supposed to do. We had no knowledge before all these letters came in from her. We did everything the minute we found out about it. Yes, we did have a manager who was very ill, and he passed away. But we had it all taken care of. We hired another manager before when we first found out that they were ill, and he took care of everything that they asked for, we did. and we did everything that any of the tenants asked for. And I have in my file tons of sheets of what we've done for every tenant. So we try with all our buildings to take care of every tenant and do whatever is wrong to make it right. If they have any other questions or any other problems, we have a system where they fill out a form. It's a repair form, and they slip it into the manager's office, and we repair it. So I think we're trying to make everybody happy, and that's what we're here for. Thank you.
Thank you. Okay, Jean Morello, followed by Deborah Senapol.
Hi, good evening. First, I'd like to start off by saying before Jackie and Jesse Pizzanti became ill, there were many problems. I have letters dating back to 2008 of trying to get items fixed in my apartment, which did not get fixed until I filed a petition. I always felt that I might be, I can't even think of the word, I'm just so nervous. So this all happened before they even were ill, that we had difficulties. And that's all I can think of right now, I'm sorry.
Okay, thank you very much. Deborah Senapol.
Hi, I'm Deborah Senapol, and we were all, when we went to the rent control hearing mediation, we were all given letters saying that we were allowed to bring an attorney. I did bring an attorney. Shelley was advised with her team that she could bring an attorney, and it was her choice not to. I did not have to advertise beforehand that I was coming with one. So also, in addition to what Jeannie had said, we had submitted letters to Jesse and Jackie, also to Brenda, who is our present corporate manager that assisted Jackie and Jesse. We faxed the letters, we emailed the letters, and to Jesse and Jackie, we gave them in person. And for years, they were totally ignored. I mean, just ignored and not done. And that's why we went to the rent control petition. So that's how the whole process started, and that's everything we had to go through to get things repaired.
Can I ask you a quick clarifying question? Just of the pages and pages we received of repairs, is your apartment among? What was your apartment unit number?
I'm 107 with Jeannie, and the letters that the attorney accepted, those were letters from the tenants that all had similar problems. Part of the appeal that was made by Shelley is she suggested that either we told people what to say or that we wrote the letters. So the new letters that were submitted were the exact same letters that were accepted and submitted to the court, but the tenants went and signed them. And that's what we dropped off to rent control 2 weeks ago. They signed them saying on the date that they were brought to the hearing, that they, in their own words, wrote the letter and signed the letter. So they just re-verified that it was theirs and that we did not tell them what to write. Each letter is totally different based on each apartment situation. There's nothing common between all of them other than people have asked for years and years to have repairs done, and they were always ignored by Jesse and Jackie.
Thank you very much for your comment. All right. Does anyone have any questions of staff before we begin discussion? Anyone wish to chime in? If not, I will. Okay, Commissioner Duran.
Yes, thank you. So, as I'm hearing the speakers talk, and it's something that I have to remind myself as well, is the focus of why we're here and what we're determining. I don't doubt that there were issues in the past. There's been plenty of evidence that there were issues that were not resolved in a timely manner, and that was the reason for the decrease then. Since those things have been remedied, though, that's kind of the end of that chapter. And my understanding, correct me if I'm wrong here, is that we're here to review whether the hearing examiner in granting that rent decrease did it appropriately, even though the repairs had already been made to the things that were done. And it sounds like based on, there was no evidence in the file to show that there was a reason for a decrease to continue. And so we're here to determine whether that decision was proper, not whether things weren't done properly before or for how long. So I just wanted to make that clear, that's my understanding as to what we're here to decide, and not the bigger issue maybe of all the things for all the years that weren't done properly. Thank you.
Commissioner Flora.
Yeah, I echo what Commissioner Duran is saying, because this is one of those frustrating cases, petitioners, where I'm reading what's happened. We've gotten new information which we really are not supposed to consider because it was beyond the date of the hearing. Yeah, I just want you to know I believe you. I'm sorry that you've had to endure all of this. It sounds like the owners certainly feel they've made an effort. There's evidence that when pressed, they got some things together. So it's one of those real tough technicalities where this isn't the end, this isn't the final chapter, but we've got to go with the law and our process. My only advice would be the staff has recommended, and I certainly agree, that we would waive our usual 6-month period where you would need to wait before you would bring new evidence again. So I would say, if things are happening, keep documenting them, keep journaling them, dates, times, and I hope that they won't be, and I hope that there will be a good coming together with ownership, and that they'll understand your needs and take care of them. But it's an unfortunate case because I see what's going on, but we just don't do punitive damages here. That's just not what we do. If we did that, we'd probably be giving away a lot of money over the years. We have to go with what's in evidence. So, yeah, same as what Commissioner Duran said. It's one of those things.
Commissioner Trosas.
I would have to echo what my fellow commissioners stated. We are really only permitted to grant a rent decrease based on an ongoing maintenance condition or a reduction of a housing service, and I just think that the record, as reflected herein, does not support that rent decrease at this current time. And I also wanted to flag that I am supportive of waiving the 6-month requirement. So obviously we're not giving you any advice on what to do, but should you gather your documentation and come back with further information as was provided, I think I'm supportive of waiving that six-month waiting period, and therefore based on that I'm ready to adopt the findings of fact, unless Commissioner Foster wants to say something.
Thank you. So I am also in favor of waiving the 6-month period. So tonight's agenda, I won't waste time rehashing what my fellow commissioners have already said so well. Tonight's agenda is a great example of our process at the Rent Control Agency. It serves both landlords and tenants. There are petitions available to both, and in many different cases tonight, both parties have availed themselves of the process, and we're really glad that it works. We're glad that you're here, and we encourage you to keep coming to us if there's anything we can do to be of service to both parties. So we'll entertain a motion to vote on this case.
Okay. Well, it is your last meeting. I move to approve the findings of fact and conclusions of law.
Is there a second?
Second.
Yeah, sorry. So, excuse me. So therefore, that would be a reversal of the hearing officer's decision and an approval of the findings of fact and conclusions of law as stated in the staff report.
And the waiver?
And, of course, which states that we waive the 6-month rule contained in Regulation 4005B3.
Second.
All right. Let's call the roll.
Commissioner Trosas?
Yes.
Commissioner Duran?
Yes.
Commissioner Flora?
Yes.
And Commissioner Foster?
Yes.
Motion carries.
All right. Moving on to the next case. We have case B2. It's case D5066, 1112 11th Street. Unit 2, Appellant D. Davidson, Manager on behalf of Savannah Property Management, LLC Landlord. Landlord appeals decision granting rent decreases for reductions in housing services. May we have the staff report, please?
Commissioners, Mr. Davidson has appealed a decision that awarded rent decreases to tenant Eduardo Vasquez, arguing that the decision was wrong for 6 reasons. First, in his pre-petition notice to the landlord, Mr. Vasquez complained of defective laundry facilities, floor, walls, door and laundry sink very dirty, deteriorated, clothing, laundry line poles rusted, and walls with cobwebs. In the petition itself, Mr. Vasquez simply checked the box indicating that he sought a rent decrease due to defective laundry services. Similarly, the pre-petition notice to the landlord detailed specific problems with landscaping, while the petition itself simply identifies landscaping as a problem. Mr. Davidson argues that the notice and petition must match exactly, otherwise he's deprived of due process. Mr. Davidson is essentially arguing that by including greater specificity in his pre-petition notice that was included in the petition itself, the tenant somehow failed to inform him of the nature of his complaint, with the result that the hearing on the petition deprived him of due process. His real complaint seems to be that he was not that he was deprived of his constitutional right to due process, but that Mr. Vasquez failed to comply with the board's regulation that requires a tenant to give a landlord 30-day written notice before filing a petition. The notice required by the regulation must specify the conditions or the loss of housing services on which the petition will be based. Mr. Vasquez's notice clearly did so. The notice left no doubt as to precisely what problems he intended to base his petition on if those conditions were left unresolved. Mr. Vasquez did exactly what the regulation requires. Yet Mr. Davidson cites a previous hearing officer decision in a prior case between the same parties in arguing that the language of the pre-petition notice and the petition must exactly match. First, except for factual findings, administrative decisions in prior hearings have no precedential value. But even if they did, that prior case is distinguishable from this one. In that case, the things that Mr. Vasquez had complained of in his pre-petition notice were different than the ones for which he sought a rent decrease in his petition. Here, they're the same things, and the hearing officer only gave him rent decreases for those things. Mr. Davidson was not prejudiced and could not have been in any way reasonably confused by the fact that Mr. Vasquez identified only laundry and landscaping as problems in the petition when he had identified a litany of specific problems in his pre-petition. The second reason, although the hearing officer granted a rent decrease because the laundry facilities are unclean, Mr. Davidson argues that the photographs show otherwise. The hearing investigator observed cobwebs on the walls and a stained, discolored sink as documented in the photos. Mr. Vasquez complained that there's no consistent cleaning or monitoring of the laundry room for cleanliness except when the inspector's coming. Mr. Davidson dismissed the stain and dirtiness of the sink as patina and argued that photos don't show cobwebs on walls or dirty floors. The photos show otherwise, and the record supports the decrease granted. The hearing officer conditioned removal of the decrease to a showing that the owner has provided regular cleanings over a 3-month period. That condition reasonably ensured that the facility is cleaned on a consistent basis. The third reason was that notwithstanding any existing problem with the landscaping, Mr. Davidson says he intends to remedy those problems in the future, and that the decision identifies Mr. Davidson as the owner LLC's managing member when in fact he's merely the manager of the property, and that the decision incorrectly states that Mr. Davidson did not submit documentation from the plumber who serviced the water heater when in fact he did. And finally, that the decision refers to a prior decision concerning the property that was issued in 2014, but it's mistakenly written as having been issued in 2016. The purpose of an appeal is to give a party an opportunity to ask the board to reverse a decision because the hearing officer has made an erroneous finding of a material fact or a legal conclusion. That Mr. Davidson intends to remedy the deficient landscaping in accordance with the city's guidelines is not relevant to the question of whether the hearing officer erred in a finding of fact or conclusion of law. It cannot be the basis for an appeal. and Mr. Davidson's pointing out clerical errors about the date of a prior decision, what his title is, and whether he submitted documentation from a plumber when no decrease was given for plumbing conditions. These errors do not point to an erroneous finding of a material fact or a legal conclusion, and therefore they're not the basis of an appeal. In his written response to the staff report, Mr. Davidson raises new arguments that he did not raise in the appeal that he filed. He may not do so because the deadline to file an appeal and raise issues on appeal has long passed. He states that the hearing officer erred in precluding testimony by Mr. Davidson's assistant, Ms. Andressen, that doing so was a failure to provide him a reasonable accommodation for his disability. At the start of the hearing officer told Mr. Davidson and Ms. Andressen that she could stay to provide him assistance, but that if she was going to be a witness who would testify, witnesses were going to have to leave the room until it was their turn to do so. Ms. Andressen decided to stay. When it was Mr. Davidson's turn to present his case, he asked to have Ms. Andressen testify. The hearing officer stated that Ms. Andressen had chosen to stay and help him instead of leaving to testify as a witness or other witnesses had in this very same hearing. Mr. Davidson never made a formal request for accommodation of a disability. Instead, the hearing officer asked him why he wanted Ms. Andressen to testify, and he said that she had personal knowledge of why there were paint spots left on the security door. The hearing officer found that to be unnecessary and declined to allow her to testify, and the hearing officer never granted a decrease for that item. So Mr. Davidson was not prejudiced even if he had requested a formal accommodation for a disability, which he did not. Mr. Davidson also suggests in his written response that he cannot do more to his landscaping because of city guidelines, and that he has asked his cleaner, Anita, to clean the laundry room on a regular basis. Neither of those are issues that are properly before the board on appeal. Instead, he may raise them through a request to verify compliance with the hearing officer. My understanding is that he has filed a request already. For all these reasons, staff recommends that the board affirm the hearing officer's decision.
Thank you. We'll hear from one member of the public. Mr. Eduardo Vasquez, you've requested 3 minutes. When you start, no rush.
Okay, I just want to more or less describe the landlord of the apartment I was living at for almost 10 years. Never take care on a timely manner of the request for maintenance. He's like sending 3 days notices based on lies, or like one day he just brought a plumber after this decrease. I'm
sorry to interrupt. Because this is not a hearing on the character of either party or about what the landlord is like as a landlord or what the tenant's like as a tenant, but only about the correctness of the hearing examiner's decision based upon the evidence that was in the record. It's important to confine, for the speakers to confine their remarks to that issue.
Okay. Well, regarding the hearing it's my second hearing in order to get the repairs done on a timely manner. This landlord was using the length of the process to get the hearing established, the date, and then after the hearing is the conclusion of the hearing officer is done, then after that he's just having some extra days in order to fix the problem. So I started more or less in March, and we are in November, and still I'm not having any conclusion for here. So I think that is a failure, since you are here and defending how helpful is the agency of rent control. I think that there are some gaps of service for people that are paying on time the rent. We are just covering our responsibilities, paying on time and being aligned with the contract that we signed. But these guys are using the gap that you have, that you didn't even notice, that it's been like almost 6-9 months until we get some response. And sometimes the hearing officer is just letting them go without just covering or being responsible for something that is shown on the pictures by the the inspector that he didn't paint the building in more than 10 years. He's patching here and there, and he just started painting because he thought he was going to be...
Sorry to interrupt again. The issue of the painting of the building is not an issue in this appeal.
Okay. Yeah, but you read about something that wasn't in the appeal too, that was talking about other stuff of the laundry and the painting on the floor. So you mentioned that, so you brought that to account, correct? And you also brought to account that he brought Mr. Anderson, or wanted to have having
1 minute left.
The disability of the entering at the hearing. So you mentioned that it has nothing to do with the appeal. So you are talking about stuff that doesn't have to be it's not related to the appeal, but you're not allowing me to just complete that. So I think you have to be fair. Or you don't talk about that because it has nothing to do to the appeal, and I will just do that too. But if you're doing that and you are not allowing me to do that, where is the fairness here? Okay? So the public landscape, he is just appealing about the public landscape that is not the regulation is not allowing him. That's not true. I talked to Jessica Sachs from the Santa Monica public landscape, and I read what he said, and it has nothing to do. And I also read the park,
Mr. Vasquez, thank you very much for your comments.
It's 3 minutes. I asked 5. It's 5 minutes. I told him 5 minutes because there are 3 topics.
He's not the appellant.
Oh, right. So the appellant themselves, which is your landlord, is the one who's entitled to up to 5 minutes. You, as a respondent, are entitled to up to 3 minutes.
I wasn't told that, but anyway, so I'm just...
Okay. Thank you for your comment. So I'm first in the queue. I want to say I feel strongly that the staff report is completely accurate, and that the conclusion that staff has reached in recommending to deny the appeal and affirm the hearing officer's decision is clear. Sometimes you only wish you could do more. Staff, can you remind me, did we adjust, and I'm sorry that I didn't think of this question before now, because I usually like to ask those in advance. Did we adjust, much like we've done the construction-related decreases backwards in time, have we entertained the notion, or are we able to entertain the notion of doing that for a lack of maintenance over 6 to 9 months?
The charter does not permit that.
But it could if it were amended.
If the charter were amended, yes, but that's
right.
what it would take.
That's all I needed to know. Thank you. Commissioner Trosas.
I mean, I understand the tenant's concerns about the length of the process. I hear that. I, similarly to Commissioner Foster, was also asking that same question. And it is unfortunate that you do have to wait that waiting period pursuant to the charter, although that is something that we could take to the voters to change. We ourselves cannot change it. Given what the information we've received in the staff report, I also agree with the staff report's recommendation. I do agree that we affirm the hearing officer's decision. I agree with the $50 rent decrease as provided herein, and I don't have any further comments.
Commissioner Flora?
Well, and I don't mean any disrespect to Mr. Vasquez at all by saying this, but because it doesn't seem very clear, we are finding for Mr. Vasquez here. So we agree that he deserved the rent decrease. I know he wanted more, and I do hear you, sir, about the lengthiness of the process. It is unfortunate, but I just wanted to get that on record, that it sounds as if we were, not in agreement with the petitioner, and we are to a large degree. So I will vote to support.
All right, is there a motion?
I'll move that we, I never do this right. I move that we affirm the hearing officer's decision, and et cetera, et cetera.
And deny the appeal?
And
the landlord's appeal?
Yep. That is correct.
Is there a second?
Second.
All right, please call the roll.
Commissioner Flora?
Yes.
Commissioner Duran?
Yes.
Commissioner Trosas?
Yes.
And Commissioner Foster?
Yes.
Motion carries.
All right, moving on to item 10B3. Item N-0263, 326 San Vicente Boulevard, Unit A, appellant R. Levine, tenant. Tenant appeals decision finding her a tenant not in occupancy under Regulation 3304. May we have the staff report?
Commissioners, Rhoda Levine rented her apartment at 326 San Vicente, Unit A, back in 1989, and she has not lived there since April of 2017 when she moved to Maryland and became a resident of a senior assisted living facility. In recent years, Ms. Levine's health had begun to worsen. Her eyesight and hearing failed, and she had a series of falls, some of which required transport to hospital by ambulance. She needed a walker for support and eventually caregivers to help her with her daily life activities. According to her property manager, Ms. Levine also suffered from memory loss. Ms. Levine moved to Maryland because her niece lives there, close to the assisted living facility where she now stays. She briefly subleased her apartment to some of her attorney's relatives, and by the time of the hearing investigator's site visit in August 2018, the apartment was empty except for larger pieces of furniture. Her landlord filed a petition asking the board to find that Ms. Levine is a tenant not in occupancy and to increase her rent under Regulation 3304. The hearing officer granted the petition because he found that Ms. Levine had been absent from her unit for nearly 18 months, and although the absence resulted from a medical condition, it does not appear to be a temporary absence. Courts have recognized that Regulation 3304 ensures that beneficiaries of the rent control law are those who principally reside in their unit. Once a landlord makes a prima facie showing that a unit is no longer a tenant's usual residence of return, a hearing is scheduled to give the tenant the opportunity to rebut the landlord's case or to show that the tenant qualifies for one of the exceptions listed in the regulation. Here, the landlord made a prima facie showing after an 18-month absence. It was Ms. Levine's burden to show that her absence qualified as an exception under the regulation. An extended absence may be excused if the absence is a temporary one, such as from a hospitalization, military service, or seasonal employment. Ms. Levine submitted no evidence that her absence is temporary. Instead, the record suggests that in addition to having her mobility impaired and having lost the ability to see or hear, she suffers from memory loss and resides in an Alzheimer's unit at the facility. Ms. Levine's attorney submitted a declaration purportedly signed by Ms. Levine saying that she is in Maryland seeking medical treatment, that her furniture is in her apartment, and that her possessions are in storage, that she desires to return to Santa Monica to live, and that she disagrees with the rent increase. But it is unclear from the record whether Ms. Levine had read the declaration or even had it read to her. And given her residence in an Alzheimer's unit, it's unclear to what extent she appreciated the declaration's meaning if she had. And the declaration includes no indication or evidence that she will be able to return. The hearing officer, therefore, reasonably gave the declaration little weight. Ms. Levine's attorney argues that the inquiry under Regulation 3304 interferes with Ms. Levine's right to sublease. She had subleased her unit to her attorney's relatives for several months, although the unit is currently vacant, and the parties dispute whether her lease actually provides her with a right to sublease. But the question is inapposite to this matter. Regulation 3304 does not concern itself with Ms. Levine's right to sublease. That's a question under state law. What matters is whether a preponderance of the evidence shows Ms. Levine's absence to have been a reasonably temporary one. In a recent case, Bleiberg Investment versus Santa Monica Rent Control Board, a tenant had moved out of her apartment to live in another one where she could take care of her cousin who was seriously ill. She hoped to return to her apartment after her cousin had several more surgeries, though was uncertain whether her cousin would necessarily recover to live independently. The board found that the absence qualified as a reasonably temporary exception because of the medical condition. In the writ against the board, the court held that absences with an indeterminate date of return are not reasonably temporary absences and ordered the board to reverse its decision. Here, Ms. Levine has failed to produce evidence that prove that her absence has a determinate date of return or otherwise a reasonably temporary one. Therefore, staff recommends that the board affirm the hearing officer's decision.
Thank you. We do have two requests to speak on this item. Mr. Mark Agerman and Alex DiBona. I hope I'm pronouncing that right. Please approach the microphone. Mr. Agerman, you have 3 minutes.
Good evening, members of the Rent Control Board. My name is Mark Egerman. I'm an attorney for the owner of the property, 326 San Vicente, LLC. Let me say that I have been impressed, having gone through a couple of hearings in Santa Monica, with the thoroughness of how you handle petitions both by landlords and by tenants. This particular case has very little factual dispute. One of the things that I want to stress is that the hearing officer acts in a quasi-judicial position of weighing the evidence, evaluating the credibility of the witnesses, and making factual determinations, and then applies the law for legal conclusions. In this case, over my strong objection, the hearing officer admitted the declaration of Ms. Levine, even though there was direct testimony by her attorney that it was prepared by his office without any communication with Ms. Levine, that he was not present when she signed it, has no knowledge as to whether it was ever read to her, and has no knowledge as to her mental capacity for understanding it. It was well within the discretion, given the overwhelming evidence and the length of absence of Mrs. Levine from the unit, at this point approximately 19 or 20 months, to reasonably conclude that she no longer carries on daily living activities in the unit, and there was no evidence to indicate that she could return to the unit. The Bleiberg case, I believe, is directly on point and is governing law which should be followed. I have great sympathy for Ms. Levine personally. She was a lovely tenant for many, many years. When there was an initial issue and we were told that she was going to return to the unit, we in writing stated we recognized her right to return. But then it became obvious that her absence was not temporary and not reasonable. So I request that the board uphold the decision of the hearing officer.
Thank you. Alex DiBona.
Thank you for your time, and yes, that's actually a perfect pronunciation of my name. I thank you very much for it. I believe this, Mr. Egerman is correct that there aren't very many factual disputes, but I think that the scope of the regulation was improperly implied by the hearing officer. It was the staff report correctly recognizes, of course, that the regulation 3304, it has a list of exceptions, one of which is hospitalization, the other is military service, Peace Corps volunteer, and educational commitments. These commitments, especially in the case of military service, do not have a definitive date of return, and they're also frequently multi-year commitments. Military service, obviously 2 to 4 years, and they're legally speaking, they can be called back up. Peace Corps volunteers, 2 years, and can re-enlist, and there's no distinction between, for example, graduate education, which can take a number of years. And we think that all these exceptions, the fact that they are all can be multi-year commitments, evidences the intent that that extended medical treatment applies and should not count against Ms. Levine. Even people with Alzheimer's who are elderly do live at home with caregivers. There was evidence on that. It was not really discussed by the hearing officer, but the effect of the decision is effectively, if Ms. Levine ever becomes well enough to return to the unit, which we hope she will, and which we certainly believe she will, she won't be able to, because she will not be able to afford or the rent increase. And there was the mention of the abuse of discretion in the declaration. We believe that in situations where tenants are absent because they're seeking medical treatment, it's very hard for them to appear by phone. It's very hard to get, they themselves can't use Skype, and their nurses, that's also very difficult. So the only way she could testify was through declaration. The hearing officer did admit it, but essentially said there's no weight. But when the central issue is intent and also the issue of her finances, that she could not afford it, we believe it was prejudicial to her because the sole evidence was that she intended to return, and there was nothing contradicting that. For example, she's not registered to vote in Maryland. She owns no property. She didn't get a license or a state ID or anything of the sort that would negate the declaration. And also, the evidence is undisputed. She needed to sublease and could not afford a rent increase of, in this case, over 200%. So the effect is essentially she would have no choice but to hopefully be able to stay in Maryland, but she would lose the home that she's occupied for nearly 30 years and had every intent to go back to. That's essentially, I would believe, the strongest argument. At the risk of repeating myself, I believe this board should find that a tenant is not, there's no question of abuse of the system. She's not renting this out as a vacation home. She doesn't own multiple units and is seeking some type of advantage. But when the extended absence is caused solely by extended medical treatment, that properly falls within the exception, and there should not be accounting against her. And that also the board has the ability, as it did in the previous case, to allow other petitions to be filed in shortened periods of time, so they don't necessarily have to drag on forever.
1 minute left.
Unless there's any questions, I have none.
I do have a question for you, clarifying question. So at 3 different points in the staff report, it's noted that she's living in a memory care wing of an assisted living home. Does she actually have a medical diagnosis of Alzheimer's?
Yeah, that was a dispute. That was a dispute fact. The only evidence that the hearing officer based that on, we would say, is hearsay. There was no diagnosis.
That's not my question, sir. Does she reside in an Alzheimer's unit?
No, and we do not believe there's any evidence of that. From our understanding and what we put forward, her diagnosis had to do with her weight, mobility, and the visual and hearing issues that were attested to without dispute, and that was the basis for needing care, not related to dementia or Alzheimer's.
I have a question for you. Thank you. Commissioner Trosas has a question for you.
Was there any medical prognosis introduced into the record as to her ability to return to her normal daily routine?
There was not.
Okay.
Thank you very much for your comments.
I appreciate it.
We'll move on to discussion. Commissioner Flora?
Yeah, I have a question for staff. I do want to get their take on this hospitalization exemption, but if we're to allow the hospitalization exemption, are we allowed to consider this hospitalization exemption? Because if we aren't, then my next question is moot.
Yes, it's not really that there's a hospitalization exemption. It's that the question is always, does the person occupy the unit as their residence, as a normal place of return? And in drafting the regulation, the board recognized that there are times when a person isn't coming home every day. For example, if they are away taking care of a sick relative, or if they have a medical condition of their own, or if they've been called up into active military service. And under those circumstances, that place is still their home, because when they're no longer compelled to not be in that other place, that's where they're coming back to. So it's not that the hearing examiner said, merely because she's hospitalized, even for a lengthy period of time, for that reason alone, the landlord is entitled to a rent increase. Rather, the hearing examiner said, the evidence does not show that this is a temporary change, a temporary absence, which is going to culminate in her return to the unit. There was no evidence in the record that she had an intent or ability to return to the unit.
Well, to what degree is it okay for her party to simply not know yet? I'm trying to get, I'm trying to make sure, because I would be very disappointed if we were doing this, subconsciously, that we aren't making judgments based on how we perceive her chances. In other words, I think that would be very discriminatory. It might even affect her health for her to learn that this has happened to her.
Yes, I can respond to that.
So that's what I'm trying to get at.
Yes, I can give you assurance that that's not the case. The way this process works is the landlord, in order to be entitled to a hearing, must first make a prima facie case. The landlord here did that, and that's not disputed. It's then up to the person who has indisputably been gone for some length of time to show, oh no, I am coming back, and here's the evidence that I'm coming back. Here's the proof that this is my intent, this is my home, and I'm returning there. The tenant here provided absolutely no evidence of any kind to show that. So the posture of this case is that there was a prima facie showing, and that prima facie showing was not rebutted. It's not the case that the hearing examiner said, just because she's hospitalized, I, the hearing examiner, am going to make a prognosis for her. The hearing examiner just had to evaluate evidence and ask what is the evidence that she's coming home, and there was none produced.
Okay, but can you give me an example of what that evidence would be? Because it seems to me that evidence that she hasn't registered to vote, hasn't gotten a state ID, is sort of like negative evidence. In other words, not negative evidence, but it's
the absence of
evidence.
It's
de facto evidence, because that by not getting those things, it may show intent to return. No.
Yes, the absence of evidence is not evidence of something, for sure.
Okay.
And it's not surprising that a person with an inability to see or hear and an absence of memory and who is in a care facility has not applied for a driving license in that state, or to vote, or other things. So I'm not sure what weight should be given to those things in any event, but the basis for the hearing examiner's decision was not that she didn't get a driver's license or that she didn't register.
But what were examples of evidence? Right. What would they be?
In this case, it would presumably be a prognosis from the doctor. Oh, this is just temporary, and she's going to be able to return. No such evidence was produced.
Or her niece could have written something, and they just didn't. Okay.
Right.
All right. That's unfortunate.
So I put myself in the queue because I do want to say, when these cases come before us, we don't take them lightly. We've had numerous other cases where tenants did fight for themselves during the appeal process to stay in their unit at the same price. These decisions are never easy for us to make, and we try to be as thorough as we possibly can, in the spirit of disclosure, but also as a way to perhaps persuade my fellow commissioners to my point of view. I own an assisted living and memory care community, so I am somewhat of an expert on the daily comings and goings of the residents of my facility. I am not her medical doctor, nor have I ever met the woman in this case. Discharging someone to home can be illegal in most states if they have certain diagnoses and a certain lack of ability to care for themselves in their primary home. So the fact that she's already been living in this place for a very long time at this point is indicative, at least to me, that she's probably, the odds are that she's not returning. But that's not what compels me here. That's more circumstantial. What compels me here is that in other cases, we have seen clear responses from tenants who stated why they are gone or still gone or when they intend to come back. And that is either compelling or not compelling. So in this case, the fact that we don't have that statement, we don't have the luxury of wait. There's no process, am I correct, for us to wait to see if perhaps she would. The case was brought when it was brought, and I think that the defendant has the party has a responsibility to be able either comply and reply within that time frame or not. In this case, that's as heartbreaking as it is for seniors to face these kinds of issues that do change their lives and sometimes remove them from their own homes. We have no choice but to follow the letter of the law and our duty. Thank you. Commissioner Flora? Oh, did you not mean to go in again? Commissioner Trosis?
Yeah, I mean, again, the assisted living model is not in the hospital continuum of care per, the research here, and the tenant has been now absent for her unit for a considerable period of time, over a year, not in a hospital, does not fall under any of these exceptions. To me, what was really dispositive was the fact that there was absolutely no not that I saw, and again, her attorney testified, doctor's declaration stating that there would be an improvement of conditions such that she would be able to return to her home. Her personal possessions are not at the property. She is in a Sunrise facility. I can just say my grandfather, who has dementia, is in a Sunrise facility. He is not returning to his house. I'm not using that as evidence, but I can state that the fact that there is no refuting doctor's note, I think, to me, really is dispositive, and I would uphold the hearing officer's determination here.
Is that a motion?
I move to uphold the hearing officer's determination and affirm their findings of fact and conclusions of law.
Is there a second?
I'll second.
Having a motion and a second, we'll call the roll.
Commissioner Flora?
Yes.
Commissioner Trosis?
Yes.
Commissioner Duran?
Yes.
And Commissioner Foster?
Sadly, yes.
Motion carries.
Thank you. Sure. Commissioner Flora has something.
Before everybody runs off and we move on to other items, Michael Millman, who's a housing provider, got me cupcakes tonight because it's my last meeting as a commissioner. And I'm sure he wouldn't mind if I offered everybody a little cupcake. Does anybody want a cupcake?
Keep the sugar going so you can get through the meeting with us.
Well, I'll tell you what. I'll just leave them over there by the speaker's rostrum, and you can take one or not. Does everybody want one here?
The royal taster.
You wanted to get me. You should have done it 8 years ago.
All right. After that generous offer by Commissioner Flora, item 11A has been pulled from the agenda by staff. Item 11B will be the next item we will hear. The board will consider whether to adopt a proposed new subdivision D to Regulation 1003 respecting commissioners' participation in board meetings by teleconference. Can we hear from staff?
Yes, I'll be very, very, very brief. The board considered this at length in its last meeting and decided, as the result of that, that it would that it sought from staff a regulation that would do two things. One, codify the permission of the board to commissioners to appear telephonically at board meetings, subject to only two limitations. One are those imposed by state law in the Brown Act, and the other is that only one board member at a time may participate telephonically. The regulation attached to the staff report does that. Thank you.
All right. Any discussion? We have no speakers on the item. Any discussion of this item? Commissioner Duran, Commissioner Flora, Commissioner Trosis? Okay. Commissioner Duran?
Thank you. When we heard this item last meeting, and perhaps the start was the meeting prior to that, I had voiced my concern about a topic such as this, and for fear of the slippery slope. I just wanted to convey again that I did not believe and do not believe that it is of members of the current board or the soon-to-be board where that would raise my concerns, but it was just later on the unknowing that raised the issue that I had about abusing the privilege that we are about to vote on tonight. So I just wanted to say that was the concern that I had. I am fine and satisfied with what's been proposed, and I'm willing to move forward with this item as proposed. Thank you.
Commissioner Flora? Commissioner Trosas?
I don't have any comments. This is pursuant to what we discussed last time, and I'm ready to move the item.
So I'll go next. So I have no issue with participation by teleconference in general. However, the laundry list of items that are required to meet the standard of the Brown Act require numerous things to happen and in a certain order and by a certain time. And I had the occasion to experience that we almost tried to do it this time, and we actually ran up against a very, very tight deadline in which the clerk had to locate me physically for a signature, and if not me, then the next person. But what if they're downtown or in another, and then get it to the clerk not by 7 p.m. 24 hours ahead, but before they leave for business and can take their last item of business at like 4:15 in the afternoon, et cetera, et cetera, et cetera. The only thing that I might add to this as an edit only would be to require some sort of minimum time that we set for ourselves to allow staff and the current chair or vice chair to be reached and to call for the special meeting and to get the full Brown Act compliance with location, address, room number, all of these things set in place before the 24-hour deadline. It would just seem that we might need to extend the decision-making process as to whether we're going to participate by teleconference or not to perhaps 48 hours, before, or 72 hours before. 72 hours is one possibility because it also is reflective of other requirements for late agenda. Well, just a second, you can say it. What I'm suggesting is, rather than waiting till exactly 24 hours before 7 p.m. the night before the meeting to let the public know that perhaps we should make an agreement among ourselves, since this is being writ out of cloth, for our board, that we voluntarily adhere to something longer, unless there were an emergency situation perhaps, but give our 48 hours or 72 hours notice to staff so that they can start the paperwork process of notifying the city clerk, blah, 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 blah. So we almost ran into that deadline yesterday. And it was very, very tight, and had one of us not been available to sign it in time, it could have been an issue to get it back to the clerk before close of business on the prior day. So it's not just about the Brown Act being 7 p.m. the night of the meeting, or 6 p.m. in the case of a closed session. I'm just saying there just needs to be a few more hours. So I would just throw it out there for discussion to propose 48 hours or 72 hours. I'm open to either. Commissioner Flora?
I actually like that idea. I would go with 72 hours because it's consistent with some of our other deadlines, deadline minimums. And looking at this list on our memo of the things you have to get right for these, I can't believe that we're only going with 24 hours. And I didn't know that you had to be chased down for a signature to approve this. So I think this is...
I didn't either, really.
Well,
so I think it needs a few days.
That would certainly ensure that we had enough information, the proper information, to timely post the special meeting.
Yeah,
and it becomes a special meeting because somebody is appearing someplace other than the usual place where the meetings are called. So it's automatically a special meeting when somebody's teleconferencing. The Brown Act requires that posting 24 hours in advance, but as Chair Foster said, the clerk, we need it earlier to get it to the clerk so it can be posted. And in order to call a special meeting, there's a special notice that has to be signed by the chair before it can be posted. And so that additional time to do that would be helpful. If 72 hours is agreeable, that would be, we would recommend.
Yeah, I didn't even think of that because the clerk's not going to be there past 5.
And they need to start
So
it
it's not
before
even
5.
really 24 hours in reality, even though it's 24 hours in print, so, or in understanding. So I would agree with that suggestion, and I wouldn't go 48. I'd go 72.
Commissioner Duran?
I agree with the 72-hour proposal for all the reasons that are stated, and I would like to formalize it though, and not because you had referenced it being for this board here, but I think we could formalize it into this item, so with that moving forward, that's part of that's the requirement. That's something that I would be in favor of.
Commissioner Trosas?
I didn't realize that this had to be a special meeting if someone was appearing by teleconference. I guess that flew over my head. But to me, the 72-hour rule, even though we're deeming this a special meeting, I think the 72-hour rule should definitely apply. I'm fine with adding that, and other than that, I'm ready to move the item.
Should we make any sort of an exception possible if there's an emergency, or do any of the other commissioners feel that there's any need for including something in there that allows it to happen if something happens at the last moment?
My inclination would be no. I mean, we're still a 5-member board, and if there's an absence, of up to 2 people, we could still carry on with our meeting. So in an emergent situation, I don't, I don't think that doesn't bother me, not having a clause there regarding emergent situations.
If I may jump in, you're next.
No, I think I just didn't advance it.
Oh.
Go ahead, Commissioner Flora.
I would agree. Suddenly you're going to start debating what's an emergency. Yeah. So I see a real slippery slope there. And then all of a sudden, what's the point of the 72 hours? So,
just a thought. All right. So I think what I'm hearing is that we're going to move to approve it, but with the edit and the addition of a 72-hour decision. Staff, what form do you want that language to take, just so we're clear on what we're voting on?
I'm writing it now, so if you just bear with me for a second.
We'll give you a moment. I'll take this moment to mention that I am going to switch item 12A with item 14A unless there's any objection by my commissioners for that. We'll
no
problem with that. All right. We'll pause just for a moment.
I'm thinking about how I would say it.
Yeah, I just want to split the hairs of, is it notification to board secretary and fellow board members? Because there should be some consideration of whether one of us intends to be absent or not for the meeting.
Could I just add, and Steve will back me up in this, what you're saying is that I just need notification that you're going to do it and where it's going to happen, but the person that's actually doing it will still only need to notify within where they're at 24 hours. It's just that I need to be notified so that we can do our paperwork here, but the person, wherever they're doing from, still would only have to do their noticing 24 hours ahead
at that
of time.
Location.
At that location.
Yeah. Right, okay.
We just need where it's going to be on our end.
But we would say 72 hours in advance where it's going to be, correct?
Yes,
Yeah, okay.
correct, yes.
Yeah, exactly.
Okay. Thank you. So, correct me if I have misunderstood. I'm proposing the following language at the end of what's already proposed, and that language is as follows. Any commissioner wishing to appear by teleconference must notify the board secretary no later than 72 hours before the time at which the meeting is scheduled to occur. Is that what you were...
One more time, please.
Any commissioner wishing to appear by teleconference must notify the board secretary no later than 72 hours before the time at which the meeting is scheduled to occur.
Works for me.
I think that works, but I would just ask that people give us as much notice as possible, because there's the technology piece of it is also important in that Mr. Gwynn did a test, and if there are any glitches, you want to have time to be able to work that out. So 72 hours, I think this is fine, but just the courtesy of as much advance notice as possible.
We can add that as well. We can say, it does say no less than 72 hours. It doesn't suggest that that's optimal, but we can say as much advance notice as possible, but no less than.
Maybe that.
Yeah. I think
Okay.
no less than. Yeah.
Okay. Okay.
All right. I believe I moved. Is there a second?
I'll second.
All right. We call the roll.
Commissioner Duran,
Yes.
Commissioner Flora,
Yes.
Commissioner Trosas,
Yes.
Commissioner Foster.
Yes.
Motion carries.
So the next item we have is a board discussion item of Commissioner Phyllis. But I do want to ask staff, is it customary to discuss the board member discussion item of someone who's not able to be present?
It's on the agenda, so.
I'm fine to discuss
Okay.
it.
All right. So since there is no staff report and the commissioner is not here to introduce the item, I will read it briefly and then we'll discuss. Request of Commissioner Phyllis that the board consider adopting a disclosure protocol to disclose who commissioners have spoken with, co-commissioners, and member of the public at the outset of a discussion of an issue. This will be particularly important if Proposition 10 passes and board members are having significant communications with lobbyists and stakeholders outside of the view of the public. Also, this would bring the Rent Control Board into line with practices adopted by the City Council and Planning Commission. Did you want to say something? All right. Commissioner Duran.
The concern that pops to my mind, I'm certainly for transparency, and I've said that over the years. But my concern would be a potential chilling effect on people approaching us to discuss an issue, because that would mean via this proposal that their name be disclosed in public. And they may not want to do that. And so I would rather hear their comment for deliberation and maintain their confidentiality if they wanted that. So that's a big concern for me with this. That's all.
Staff, council, did you need to weigh in at this moment? Or
I don't. It's not my intention to jump the queue in front of Commissioner Tarosis.
What? No, go.
Oh, okay.
Oh, I thought I was next.
Just to help the board with its discussions, I don't know if it wants to know this or not, but two things. There are two things to bear in mind. One is that it is already the law that with respect to the board's quasi-adjudicatory function, the board is required to disclose any communication. That's a due process requirement. It's a constitutional requirement. There's no regulation that exists that specifically requires that, but there's absolutely no reason why the board couldn't or shouldn't adopt such a regulation to codify in a regulation what is already the law. That's what the City Council did. The City Council has adopted an ordinance or bylaw or something. I don't remember what it is, but the City Council has adopted a written statement about the required disclosure with respect to quasi-adjudicatory matters. There's no jurisdiction that I've ever seen in California, and it's not a recommended thing to do for the reasons exactly that Commissioner Duran mentioned, to have disclosures with respect to quasi-legislative matters. It does potentially have a chilling effect to do that. So anyway, with respect to quasi-adjudicatory functions, it's not a bad idea, and there's no reason why you couldn't, but it is not the case that the City Council has adopted a policy with respect to legislative matters.
Thank you. Commissioner Flora?
Yeah, I certainly believe wholeheartedly in open government, all the transparency in the world. But I really wish Commissioner Phyllis were here to explain her motivation on this. I certainly wouldn't support a motion without the clarification that this is on adjudicating matters, appeals, and things like that, because I agree. If we're talking about, say, housing policy vis-a-vis things that affect landlords and tenants, and a few tenants approach me, or they email me, and I respond, "Oh, thank you for your concerns." I don't want to. I mean, that tenant doesn't want to be outed and have maybe they're in an abusive landlord situation. I don't want to have to say their name. I think that would be horrible. So, as well-intentioned as this is, unless Commissioner Phyllis is just asking us to codify what we already know to be the law for adjudicating matters, I don't think. I think this is a bridge too far. And again, how would one define stakeholders? Does that necessarily mean members of the public, or only from members of organizations that lobby on policy? So my sense is it would have to include members of the public, constituents. So those are my concerns. Yeah.
Commissioner Trosas?
Yeah. I don't, with all due respect to Commissioner Phyllis, I don't actually see a need for this. I think that we all, as elected officials, have agreed to abide by the law, and we know that when we hear something in that quasi-judicial capacity, we should disclose. Have we had any communication with any of the parties? That is our requirement. That is our duty. I think we all do that, and we would recuse ourselves in the situation where there would be an appearance of bias, to my knowledge. With respect to policymaking, I agree. I think that some people do come in confidence, especially if it's going to, affect the balance of power between landlords and tenants in a vulnerable situation. I definitely don't need to disclose that publicly. So I don't actually see the need for any further regulation.
So I'm in agreement with what I've heard on the dais tonight from my fellow commissioners. I'm all in favor of transparency, and when I was deliberating how I felt about this item tonight, I'm recalling in my 2.5, almost 3 years of service, I have seen numerous times when former Commissioner Walton or Commissioner Flora, I think several of us have stated when we know the party, whether or not we feel we can sit here in that case knowing what we know. And I think we've done that numerous times, enough to demonstrate to me that we are also honoring that function and that law when it comes up. If this were specific just to that, like you said, it's not a bad idea to codify it, but I feel like we're doing it already. It's great to bring it to people's attention, and I do think that if Prop 10 had passed, it might have been maybe expedient to and really transparent to make sure that process was very clean and very transparent. But since this is not specific, and it might also encompass general members of the public and constituencies that might be bringing us more delicate matters who don't understand that if they simply reach out to us, they might be named publicly every month. I also agree that we might not need this at this time. So I think I know Commissioner Phyllis wanted to be here, and she feels very strongly. I think she's voiced to all of us her strong feelings about transparency, and that's honorable. So unless she wants to bring back a different thing when she is present, a different item when she's present, I don't think we're going to take any action at this time. Okay. Well, you've just arrived at the point in the meeting where we go to a very austere and very important moment in our meeting. Item 12A, an administrative item recognizing Commissioner Flora's service on the Rent Control Board. Staff, would you like to begin?
Give us a report.
Yes.
May we have a staff report, please?
Tell us where it went wrong.
Well, there's obviously no formal report for this. This is just our opportunity to thank Commissioner Flora for his 8 years of service. And I want to say, Todd, that over those 8 years, I've seen kind of a big change in you in terms of, when you start on the board, Often processes are unfamiliar and just it's something new. But you have shown so much leadership in the last 4 years of your term, especially I think in the last year while we were involved in contract negotiations with the employees. I think having the institutional knowledge that you did really assisted the board as a whole and the staff in terms of completing what I think were very successful negotiations. You and Commissioner Winslow did some very important things with respect to leading the board in terms of financial considerations to make the board and the agency strong going forward towards the future. I want to thank you for that. You've made, obviously, a number of decisions along the way that have been challenging decisions. We all remember a very particular difficult decision, which I won't mention it personally, but I'm going to. Well, I thought you might. But I just want to tell you, I think you've done a great service to the community. You've taken tenants and landlords' concerns and issues into consideration, weighed them evenly, and reached good decisions. And you've done a great job being a leader on the board and supporting the staff. And I want to thank you very much for that.
Bravo. For my part, I sat up here for about 2 years before I had the opportunity to become the chair. And what you do in your first couple of years on the board, and our newly elected commissioner is in the audience, as she has been for the last several months, absorbing what everybody up here brings. But for me, watching the chairs who have come before, but more importantly, the commissioners, all of us, you have probably done the best job of anyone of balancing brevity and humor and content and law and the honesty that you bring to your viewpoints on everything are just absolutely, they're stimulating and they're really, really inspiring. And I think those of us who are more junior members we sort of find our place and our style by observing the things that we take from the commissioners who come before us. And the times that you've been able to educate me with your 8 years of experience when it comes to budgets and negotiations, you were able to, calm all of us with your vast knowledge. And that's just been a wonderful thing. And whoever gets your public service next is a very lucky institution and a constituency. Thank you very much for your service. Commissioner Duran.
Yeah, I got nothing to say. I just want to say thank you. You've been a mentor to me, and your passion about what you do here on the dais and with the community has been just admirable. I don't know why I always get emotional for things. I love you, bro. I love you.
Thank you.
Yeah, it's been something to look up to, and good luck with whatever comes next. I know you will take that same passion wherever you go, and everyone will be the better for it.
Wow. You guys are being so nice. Thank you.
Commissioner Trosis.
Well, go Sharks.
How dare you?
No, I'm kidding. I just want to say it's really the saddest part is that it's only been 2 years that we've been able to be together on the rent control board. But I know that you're going to go on to do amazing things. So this is just the beginning. I'm going to be looking for you. And I have to say that you always represent your viewpoint so passionately. You say witty, great remarks that I feel like are so quotable all the time. I would never have that ability. I've learned so much from you. I love your knowledge. I love your friendship. I'm going to be really, really sad next month that you're not going to be here. But
wow, guys.
Thank you.
So kind. Thank you.
Well, Todd, what do you have to say for yourself?
Well, I, of course, wrote a speech, so I apologize to our throngs of viewers out there, but hang with City TV just a few minutes. I did write out some closing thoughts and reflections, and I'll try to read them verbatim because I think looking up and meeting any of your eyes right now would be difficult. So let me just go on the script here and see how it goes. And I did want to get something in on the record. It talks a little bit about, I think, what we've done. So I'll just read it on here. In 2010, I was intrigued when Santa Monicans for Renters' Rights was looking for candidates for this office. I thought modestly to myself at the time that this could be an interesting and meaningful way to serve the public. After all, I became a member of SMER as a tenant in a rent-controlled building, and I cared a lot about housing issues and access to affordable housing, which has been a challenging issue in California for decades. So I went for it. And 8 years later, I'm so grateful for the experience and want to thank the voters for twice allowing me terms to serve the people of this community. It was quite an interesting and productive 8 years to serve. There have been regrettable moments, but we've done a lot of good together. Often controversial, but in my view, always moving the needle of fairness in the right direction. In 2011, during my first vote on the annual general adjustment, I seemed to surprise and concern my colleagues at the time by voting no. The case was made to me that the general adjustment is the general adjustment. It just is what it is. But I thought the 3+% increase was a bit much for many still feeling the effects of the Great Recession. And I just thought the system of setting the GA should work differently. I was even surprised by a compliment paid to me for that no vote by the late Daily Press columnist Bill Bauer. It may have been his only compliment. So I couldn't just vote no and leave it at that. I felt duty-bound to do something. Working in subcommittee with former Commissioner Bill Winslow, we studied how other rent-controlled jurisdictions measured and set their general adjustment. Almost without fail, other cities avoided the complicated and work-intensive system by which Santa Monica set the adjustment and went with either a portion of the Consumer Price Index, the CPI, or even just a set amount of increase per year, regardless of economic circumstances. The work Bill and I did together led us to author Measure GA for general adjustment, which set our annual general adjustment to 75% of the CPI. It passed in 2012 by the voters, and despite a larger inflationary increase in this last year, Measure GA definitely lowered the amount of increase for several of its initial years in action. We learned recently that Measure GA may not have solved or settled long-term questions about the future of pass-throughs as I thought it had in 2012, but I'm still proud of what we did to simplify the system, which has also saved days and maybe even several weeks of staff time each year that is now spent serving the public in more productive ways. The staff and my colleagues on the board have also worked to assist the organization's desire to modernize and become more efficient. Concerned with huge annual deficits some of us saw as less than responsible for an organization our size, Commissioners Winslow and later Commissioner Christopher Walton and I met as a subcommittee and listened to the public and staff discussing areas where savings and efficiencies could be found. Some of these efficiencies have come in one-time increases in spending, as this board has supported the purchase in recent years of IT systems and software that took us from literally using documents in triplicate into the 20th century. And the 21st century itself continues to be on its way as the staff works diligently with outside parties to modernize our systems and make our petition process and even basic inquiries more user-friendly. In other words, short-term cost for longer-term savings and better service. Other cuts did come in the form of very tough and uncomfortable decisions about staff benefits and other priorities that needed tweaking. And then in 2014, in another effort to reduce our deficits, we asked the public for an increase in the annual registration fee that landlords pay to register each of their units. But as part of our measure, dubbed Measure FS for Fair Share, which I was also proud to co-author, we for the first time divided the responsibility for the registration fee between landlords and tenants. Previously, for every year of Santa Monica's literally famous run as a rent control city, we had been the only jurisdiction to allow landlords to pass this fee through entirely to tenants as a portion of their rent. No longer. It is now shared and thus more fair. And despite skeptics' warnings and Facebook haters claiming that the Rent Control Board would instantly raise the annual registration fee to the maximum limit allowed and stated under Measure FS, we have only modestly raised the rate once in these last 4 years since the passage of FS. And the result of our efforts? Several years in a row of very low deficits and a more structurally sound rent control board. Deficits will always be a factor for a board that is as committed as we have been to keeping in check the annual registration fee landlords and tenants now share to register all apartments that fall under our jurisdiction. And yes, I know deficits are creeping up again. Budget negotiations this year were more uncomfortable than any I can remember, but I know this board will continue to find a balance and has, I think, been given several templates to follow to ensure fee payers a responsibly run board. There's even more. This organization in the last 8 years worked with other city departments to allow renters to enter into separate fee agreements with their landlords to charge their electric or partially electric vehicles. To me, this was a critical haves and have-nots issue, as it was important to us in this body that highly fuel-efficient vehicles that lower GHG emissions be a consumer choice available to not only single-family homeowners, but also middle-class renters in multi-family buildings. Very recently, I've been proud to work with my colleagues on this dais to limit pass-throughs to tenants that had grown out of proportion due to the value of, in particular, school and environmental bonds that the voters had supported. Once again, every dollar had been passed on to renters, despite the benefits and increasing building values. Despite the benefits and increased building values landlords enjoyed for living in a city with very good schools. Our cap was stringent but necessary to help several thousand renters who were seeing more than $100 per month just in pass-through costs on top of rent. This sort of statement of conclusives, looking back, is not intended to sound overly self-congratulatory. I certainly have a few regrets, but none felt as deeply as I continue to feel about the situation with the Village Trailer Park and how it was worked out 5 years ago. And if I could go back to do things differently, I would. I know it's of little comfort to those families today, but it has haunted me personally, been an active subject in therapy, and has forever tarnished my reputation with several members of the public who were rightly disappointed in me and my colleagues at the time. And I haven't always been the friendliest commissioner to every landlord that's paid us a visit in these chambers. I'm sorry for getting into it with some of you who may be watching, or in some cases who may never return. But I tend to snap at unfairness and particularly at cruelty and greed. Some of the things I've had to listen to in this chamber would make most reasonable people take issue with some of what I've called the bad apples among the far and away many more good landlords we have in our community. I will not apologize for challenging those bad apples, many of whom have come here and thumbed their nose at our very authority and jurisdiction. These types of folks remind me of a few lessons and added a few lessons in life and added a new one. Some people should never be given car keys. Others should never have been allowed to become parents. And still others should never have been allowed to own apartment buildings. But I do want to thank several of the landlords that have come to see us often, who have spoken constructively and with respect, even when we haven't agreed. Wes Wellman, Elaine Golden-Gieler, and Bill Dawson come to mind among them. And Mr. Millman, who was here, who gave me cupcakes as a goodbye present. Don't forget to grab one. If I would make a request of Action Apartment Association, AGLA, and other landlord lobbies, it would be to better police and counsel your membership. Make sure that fewer owners are giving landlords a bad name. Sanction them internally in your own ways. Mentor or nudge those you suspect are not up to snuff to treat people better and not leave serious fixes to needed appliances and other amenities untended to. Keeping your members on their best behavior will give you greater moral authority with several matters before the board. I want to thank my current colleagues on the board who have each taught me something in their own ways. You are great friends as well as colleagues, and I hope we will have an opportunity again to work closely in life. Thank you for humoring my bad jokes, my errors, and at times my very style. You are great leaders, and I wish you well. I want to congratulate Commissioner Phyllis, who's not here with us tonight, and Commissioner Duran for your re-election to another term, well earned, and congratulate Commissioner-elect Naomi Sultan, who happens to be with us tonight. She is going to be fantastic. And while I'm only coming to know her personally, I know she's going to be great because over the last 20 years, I've come to know and love her parents, Bruce and Sonia. who are probably unaware of just how high a level of esteem I hold them. And her and her knowledge of working on veterans housing issues means you'll be getting a step up from this guy. Finally, I want to thank each of you on the staff. Tracy and Stephen, you are miracle workers who are role models for civility, and I know you work extremely hard to keep this organization humming. The legal team is outstanding, and Amy's leadership in the hearings department has made most appeals and exemptions very easy to understand and straightforward. I'll close with this. We probably don't reflect on this as often as we should, but there are very few people in very few cities in the world that do what we do, or who serve on rent stabilization or rent control boards. That makes what we do very important for a community that does have one. We may be what political folks call very down ballot, but just imagine Santa Monica, my friends, if the rent control board and your rights and protections weren't there. I've used that perspective to guide my work these last 8 years, and it has made all the difference. Thank you.
Commissioner Flora, would you like to move to adjourn the meeting?
Everyone has to stay and have a cupcake
On a Saturday.
But otherwise, yes.
On Saturday.
Otherwise, yes, we'll meet on Saturday. Otherwise, yes, I'd be happy to move for adjournment.
Is there a second?
I'll second.
A reluctant second. Would you care to, sir?
All those in favor say aye.
Aye.
Adjourned. Thank you, guys. Oh.
That was so good.
That was so great.